We're all set.
Are we good to go or should we still wait?
We are all set to begin.
Very well. Everyone is here and I just been informed to get started. Let's call the case of Marks v. Sony's Rooftop Bar. My name is Judge Marvin. Scoring judges, please look to the two buttons on the lower left of the screen and make sure the audio and video is off, which I think it is. These will remain off until the end of trial. You should also have the video set to high non-video participants. This means only the three people on screen right now should be the advocates and myself. Attorneys, please make appearances.
Good morning, Your Honor. My name is Frederick O'Hara, representing the plaintiff in this matter, Sonny's Rooftop Bar. Ethel Marks, rather. I'm joined by my co-counsel, Ms. Kiana Hill. She'll be assisting me with screen sharing, demonstratives, and exhibits.
Good morning, Your Honor. My name is Jacinta Lopez, and along with my co-counsel, Ms. Sofia Nicole Bay.
Good morning, Your Honor.
We represent the defendant, Sonny's Rooftop Bar.
Thank you. Any pre-trial matters before we proceed to opening statements?
Yes, Your Honor. The plaintiff has a few.
Go ahead.
First, we'd like to invoke Rule 603, which allows for all witnesses to be constructively sworn in.
So ordered.
Second, we'd like to ask the court's preference as to if we should, as to screen sharing. Essentially, should we ask the court before we screen share every time, or should we simply give the court notice that we'll be screen sharing?
You can just go ahead and screen share.
Okay, thank you. That's all from the plaintiff, Your Honor.
Defense, any pre-trial matters?
Yes, Your Honor. The defense would like to invoke Rule 615, sequestering all witnesses except party representatives.
So ordered.
And Your Honor, we would like to state that our party representative is Sonny Mehta.
So ordered. If there are no further matters, we will now hear opening statements of each party. At this point, you should switch over to speaker view. That's the button in the top right of the screen. Attorneys, please remember to mute the audio when the other attorney is speaking. At this point, plaintiff, opening statement, please.
Yes, Your Honor. Before I begin, can I confirm that you're hearing me all right?
I got you.
Okay.
Please proceed.
The difference was who was serving her. Good morning, Your Honor, opposing counsel, members of the jury. On March 24th, 2019, Jessica Marks was visiting her friend, Morgan Levin, at UCLA. She was taking the spring break opportunity to cut loose a bit, and she had a bit to drink, but she drank responsibly. She drove only when it was reasonably safe. She walked when she needed to. She knew her limits and she stayed within those limits, except for one day, March 24th, 2019. And today, members of the jury, you're going to have to ask yourself why. What was different about that day? Every other day, Miss Marks came home without a scratch. That day, she didn't. Now, you're going to hear a couple different competing explanations for why that is. We expect that opposing counsel might bring up negligence, that Miss Marks had simply, in a 24-hour period, come to be completely reckless and not care for her own health or life. We're going to tell you that the difference was who was serving her those drinks. Both of us will have to prove, or we will have to prove beyond a preponderance of the evidence, which is essentially more likely than not, that our explanation is correct. And to do that, we're going to first introduce you to who was serving her the drinks. That's Sonny's Rooftop Bar, specifically the two workers that were working on the 24th, Sonny Mehta and Frankfurt Johnson. Both of them were licensed to sell alcohol in the state of California at the time, which means two important things for our case. First, it means that they were able to recognize the symptoms of someone being obviously intoxicated. Those symptoms include impaired judgment, red eyes, uncoordinated movement, slurred speech, and many other symptoms. Second, it means that they have a responsibility. Specifically, it means that they cannot serve minors. They cannot overserve minors who are obviously intoxicated, or else they will be liable for any harm that befalls that minor that's caused by that intoxication. That's under California's dram shop. Under preponderance of the evidence, or by a preponderance of the evidence, that that's exactly what happened. They overserved Miss Marks, and she died. And really quickly, I'd like you to all look at part 12 of the jury instructions, specifically the part that says you may and should apply your common sense. That's very important. You can't enter a world of technically possible explanations in today's case. You should only be working in explanations that make sense. And by the evidence we're going to show you today, you'll see the only explanation that makes sense is that the difference that day was who was serving her. And we'll come back before you and ask you to render a verdict of liable. Thank you.
Defense, opening statement, please.
Your Honor, members of the jury, may it please the court. Go hard or go home. That is what Miss Marks said on March 24th, 2019, the night of her death. That is what Miss Marks planned long before she had even arrived at Sunny's rooftop bar that night. Go hard or go home. Now, the plaintiff just told you a story about a girl who drives responsibly, who knows her limits. And they ask you what the difference was between that girl and that girl on March 24th, 2019. They forgot to mention a couple things in their story. Your Honor, they forgot to mention that on Sunday, March 24th, 2019, Miss Marks and Miss Levin were at Miss Marks's Airbnb. They forgot to mention that at that Airbnb, Miss Marks had some drinks of wine, and that after that, she drove after drinking. They don't mention that Miss Marks was planning on going hard or going home that night. And even though she was planning on going hard or going home, she decided to take her car to Sunny's rooftop bar, planning to use that same car to drive home after drinking heavily. They don't mention that while at Sunny's rooftop bar, Miss Marks showed no symptoms of intoxication. And they don't mention that at the end of the night, Miss Marks refused an Uber multiple times and decided to get into her car and drive home. Now, the plaintiff has brought a claim for wrongful death against Sunny's rooftop bar according to the California Dram Shop Act. That means they need to prove to you two things to hold Sunny's rooftop bar liable. First, they need to prove to you that Sunny's rooftop bar served someone who was obviously intoxicated. That any reasonable person in Sunny's rooftop bar's position would have known that Miss Marks was too drunk to continue to drink. And second, they need to prove to you that as a result, Miss Marks died. Now, the defense won't be able to prove to you not even the first of those prongs of their burden, because Sunny Mehta will come up here and testify that he is trained to identify symptoms of intoxication. He will testify that that night Miss Marks did not show any of those symptoms, and that therefore there was nothing else Sunny's rooftop bar could have done. And that is why you cannot hold Sunny's rooftop bar liable. But if it isn't Sunny's rooftop bar who is to blame, who is liable? Well, the defense has brought an affirmative defense of comparative negligence to answer that for you today. The defense has a burden as well. We need to prove to you that it was Miss Marks' own negligence that caused her death on March 24th, 2019, that she failed to use reasonable care to prevent harm to herself. And before I get into that, I want to be the first to say that it is hard to ask you to do this. It is difficult to ask you to look at the decisions of a young girl and place the blame on her shoulders. But it is what the law requires us to do. And so tonight, I ask you to listen, not just to me, but to listen to Miss Morgan Levin, Jessica Marks's best friend, tell you all about the decisions, the irresponsible decisions Miss Marks made that night. To listen not just to me and to Miss Levin, but to listen to Miss Marks herself tell you how she was planning on going hard or going home. And if at the end of the night you think that the decisions Miss Marks's way had more of a factor in her death than Sunny's rooftop bar, you cannot hold the bar liable. She went hard, so she did not go home. And that is why at the end of the day, I will ask you to hold Sunny's rooftop bar not liable. Thank you.
Before we proceed with the first witness, I remind everybody to switch back to gallery view. It's the button in the top right corner of the Zoom. It will allow us to see the attorneys and the witnesses simultaneously. And with that, plaintiff, the first witness, please.
The plaintiff calls Miss Morgan Levin to the stand. May I proceed?
You may.
Good morning, Miss Levin.
Good morning.
Miss Levin, I'm going to be asking you about a night that I'm sure was very traumatic for you. So if at any point you need a break, just let me know. How long did you know Jessica Marks?
Well, Jessica was my best friend. I mean, I've known her since 2013. We were best friends in junior high, and we were best friends all throughout high school. We did everything together, watched Netflix, hung out at parties, restaurants. We were just the bestest of friends.
At those parties, would you ever see Jessica drink?
I mean, yeah, she had we would go to parties, here and there in high school, just like any other high school kid. And she would have a drink or two max.
Right, and specifically during spring break of the freshman year, where did you see her drink?
Well, on spring break in March of 2019, we were in LA together, just hanging out, and she drank at a couple of restaurants and bars. We went to Disneyland and, a whole bunch of other restaurants, and she had a couple of glasses of wine and other drinks at those restaurants and bars.
After coming home from those restaurants and bars, did she ever decide to walk home?
There was an instance where we walked in Westwood instead of driving because it was really close. So there was an instance, yeah, where we walked instead of driving.
Okay. Moving to March 24th specifically, how many people were at Sunny's rooftop bar?
Well, there were about 10 to 12 people, I think, on the rooftop. There were 10 or so people, and then there were a couple of people downstairs in the inside area where the bar was.
And how many people were working at Sunny's rooftop bar?
It was Sunny Mehta, the owner of the bar. I think he told us, and then there was this other bartender. His name was Frankfurt. I think he was manning the bar downstairs mostly, and Sunny was on the rooftop most of the time.
How many times would Miss Marks go visit with Mr. Frankfurt Johnson?
I never specifically saw for myself her talking to or visiting Frankfurt because, like I said, I was on the rooftop most of the night. But I did see her go inside the bar sometimes, and I know Frankfurt was there.
Did you see her speak with Miss Mehta?
Yeah, she spoke with Miss Mehta practically the whole night. I mean, Miss Mehta took our orders, served our drinks, and Jessica was ordering for herself. So whenever she ordered, she would talk with Sunny.
Okay. And do you know how many drinks exactly, or do you know how many drinks do you know for a fact Miss Marks had on the 24th?
Well, I mean, she had quite a few drinks. We ordered a bottle of wine. She had like 2 or 3 glasses. I mean, I had one and she finished the rest of the bottle. She had
Objection, Your Honor. Speculation.
Response, Mr. O'Hara?
Yes, Your Honor. This witness was with Miss Marks the entire night. If she says that Miss Marks finished the bottle, then it's reasonable to assume that she saw Miss Marks finish the bottle. And that's something she observed with her 5 senses. It's not speculation, and it's admissible.
Your Honor, if I may.
You may, Ms. Lopez.
Your Honor, even though Miss Levin was with Miss Marks that night, but we don't believe she can testify to the drinks Miss Marks had completely. We don't believe, we have it on a good faith basis that Miss Levin doesn't quite remember which drinks Miss Marks completely finished. And therefore we don't believe she can testify exactly to what she had.
I think she can testify to her observations, and you're free to cross-examine her on this point if you wish to do so. The objection is overruled.
Yes,
Please
Your Honor.
proceed.
Did you get to finish your response, Miss Levin?
no, I'll finish up. Like I said, she had a few glasses of wine. She finished the rest of the bottle. She also had 2 or 3 White Claws. She had a glass of beer, and then she also had a shot at the end of the night. That was our last round of drinks.
Could you tell that Miss Marks had been drinking on the 24th, just looking at her?
I mean, yeah, her behavior was just changing as the night progressed. She was slurring her words and she had red eyes, and you could definitely tell she was drinking. I had to ask her a couple times if she was okay just to make sure, but yeah, she definitely looked drunk.
Do you know of any video of what Miss Jessica looked like before going to Sunny's that night?
There was I remember she took a video at her Airbnb that night before I went to the bar.
All right. Is what's been pre-marked as Exhibit 6 a faithful and accurate copy of the video you were just describing?
I don't have a copy of Exhibit 6, the video in front of me at the moment, but if I were shown that, I'd be able to answer.
All right. Your Honor, could we Ms. Hill, could we get that video on the screen? And Your Honor, this is constructively outside the view of the jury, as we haven't seen this video yet, or as this video hasn't been moved into evidence yet. Ms. Hill, I don't believe there's sound on this, so could we screen share with sound on?
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
Was that a truthful and accurate depiction of the video?
Yeah, that was a video she took at her Airbnb before we went to the bar that night.
Okay. The defense moves Exhibit 6 into evidence, or the plaintiff moves Exhibit 6 into evidence. I apologize.
Any objection?
No objections, Your Honor.
So admitted.
What tells you that Miss Marks is sober in this video?
Well, I mean, this is how Jessica looks when she hasn't had a drop to drink. She's talking normally. She's not slurring her words. She just doesn't look drunk.
Okay. And can we get what's been pre-marked as Exhibit 10 on the screen? Again, constructively outside the view of the jury.
Hi everyone. Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy, Mom and Dad. You've inspired me. Okay, well, go big or go home.
Is that a faithful and accurate representation of what she looked like that night?
Yeah, that was a video I took of Miss Marks at Sunny's rooftop bar that night. That's how she looked.
Okay, thank you. We can end the screen share for now.
Your Honor, objection. I don't believe that document has been entered into evidence yet.
So, Hera?
Yes, that's correct, Your Honor. I was planning on entering that document after the direct was finished, but for now she's allowed to testify to it, to having seen it. She did see it at her deposition before, so she's allowed to make statements based on it.
Ms. Lopez?
Your Honor, they also asked the question, is this how Miss Marks was acting the whole night? They didn't just lay foundation. They went through a line of questioning, and therefore we believe either opposing counsel should enter the exhibit now, or either that line of questioning should be stricken from the record.
If you're going to try to enter it anyway, do you just want to enter it now while time is stopped?
That sounds good to us, Your Honor. The plaintiff moves Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. We believe we have it. May I proffer, Your Honor?
You may.
Your Honor, we have it on a good faith basis that neither of the employees of Sunny's Rooftop Bar were present when this video was taken. And the issue today is whether Sunny's Rooftop Bar served someone who is obviously intoxicated. Therefore, we don't believe that this video can be entered into evidence as an accurate representation of Miss Marks's behavior that night in the presence of the employees of Sunny's Rooftop Bar.
Just to clarify, is this a 403 objection or is this under another rule?
403, Your Honor.
Do you want to speak to that, Mr. O'Hara?
Yes, Your Honor. The fact is that this is in fact a video of Miss Marks from that day. Regardless of whether it was seen, our charge isn't necessarily proving that Miss Marks was obviously intoxicated in front of Miss Mehta, just that she was obviously intoxicated that day. So if she has red eyes and slurred speech in this video, it has probative value as far as showing that she had red eyes and slurred speech throughout the rest of the day.
You have a response, Ms. Lopez?
Yes, Your Honor. Again, the issue today is whether or not Sunny's Rooftop Bar served someone who they knew was obviously intoxicated. It's important for Sunny's Rooftop Bar to have seen Miss Marks acting that way, for them to have served her if she was obviously intoxicated. That's why we believe it's important for Sunny's Rooftop Bar to have been present when this video was taken. Otherwise, we don't believe it's important to today's case.
Mr. O'Hara?
Yes, Your Honor. Again, this is the only video we have of Miss Marks from that day. There's no other video that shows her in front of Miss Mehta acting the same way. There's just simply some things that we'll have to do that have probative value, even if they weren't necessarily observed by the workers.
I don't think this is so substantially prejudicial. So I'm going to overrule the objection. Please proceed.
Yes, Your Honor.
No further questions, Miss Mehta. Thank you.
Ms. Lopez, cross-examination?
Yes, Your Honor. Miss Levin, I'm very sorry for your loss. We'll try to get you off the stand as soon as possible. We really appreciate you being here to testify. Miss Levin, now you claim that you were talking to Miss Mehta the whole night, correct?
I talked to her when I ordered drinks, and whenever I had to get a drink, yeah, I talked to her.
Right, and that was around 30 seconds each time.
I would say so. Our interactions were pretty brief. We just, whenever we talked, whenever we had to order a drink or two.
Right, your interactions were all pretty brief.
Whenever we ordered drinks, they were brief.
Thank you, Miss Levin. Now, Miss Levin, you started out the night at Miss Marks's Airbnb.
Yeah, we started the night at the Airbnb. She picked me up around 6, and then we got there between 7 and 8 and spent about 45 minutes to an hour there.
But at the Airbnb, you and Miss Marks had 1 or 2 glasses of wine?
I had a glass of wine, and then Jessica had one or two.
Miss Marks, you would recognize a photo. Miss Levin, you would recognize a photo Miss Marks posted on her Instagram from that night.
I do think she posted a couple of things on her Instagram that night. One of them was a photo.
Co-counsel, could you please constructively, out of the view of the jury, screen share Exhibit 5? Miss Levin, this looks like a fair and accurate version of the photo I just mentioned.
Yeah, this was a photo that she posted of the bottles of wine that she had at her house at the Airbnb that night.
And Miss Levin, it doesn't look like it's been changed or altered in any way, shape, or form.
Not to my knowledge.
Thank you. Your Honor, we would like to enter this exhibit into evidence.
Any objection?
No objection, Your Honor.
So admitted.
Yes, Your Honor. Co-counsel, could you please go on to the next slide? Now, Miss Levin, you can see that Miss Marks used the hashtag go big or go home on that post.
Yes, ma'am. That's a hashtag that she put on there.
Thank you, co-counsel. You can stop screen sharing.
Objection, Your Honor, as to hearsay.
Your Honor, if I may.
You may.
Your Honor, this falls under party opponent.
Any response, Mr. O'Hara?
Just that this witness hasn't line of questioning hasn't laid the foundation yet, that necessarily this account is in fact owned by Morgan Levin, or Miss Marks rather.
Ms. Lopez?
Your Honor, we entered the foundation that this was a photo taken by Miss Marks that night at her Airbnb. We don't understand what other foundation we would be able to lay. This is her account, and Miss Levin just testified to that she posted that picture.
My question for you, Mr. O'Hara, is if you think this is hearsay, then why did you not object to it when it was offered for evidence, when the exhibit was offered into evidence? It seems the objection is untimely.
Understood, Your Honor.
I'm going to overrule the objection as untimely.
Yes, Your Honor. Miss Marks and Miss Levin, you would also recognize a video Miss Marks posted on her Twitter that night.
Yes, I would.
Co-counsel, could you please screen share Exhibit 6? It's been previously entered. Could you please play that video, co-counsel?
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
Miss Levin, in this video, it was taken before you arrived at Sunny's rooftop bar.
Yes, it was taken at Jessica's Airbnb that night before we got to the bar.
And you can see that in the video, Miss Marks says, go hard or go home.
That's what she says, but I don't know what she meant.
Right, and as she says, go hard or go home, she raises her glass.
That's what she does in the video, yes.
Yeah, so even before you arrived at Sunny's rooftop bar, Miss Marks was already saying things like go big and go hard.
I'm sorry, I don't quite understand your question. That is what she said in the video, yes.
And in the picture, she was saying go big.
That is what she said in the video, yes.
So before she arrived at Sunny's rooftop bar, she was already saying that?
Yes.
Now, I want to talk about some other plans Miss Marks made that night. Now, when you left for Sunny's rooftop bar, Miss Marks didn't call an Uber.
No, she drove. She had a rental car that she decided to drive to the bar.
That's right. She decided to drive in her own car to the bar.
Yes.
Even though she said she was going hard that night?
I like I said before, ma'am, I don't understand, or I don't know what she meant when she said go hard or go home. I mean, I was there that night at the Airbnb and I watched her take the video, but I wouldn't be able to say what she meant. But to answer your question, she did drive to the bar.
And she'd never driven to Sunny's rooftop bar before.
No, this was Jessica's first time in California.
And she was going to be driving at night.
Yeah, it was night when we got to the bar. We got to the bar at 9 and we left the Airbnb at 8:30. So it was early in the night.
So she was planning on driving to the bar on an unknown highway at night, going hard, and then driving back to the Airbnb on an unknown highway at night.
That is what she drove to the bar, yes, and she did get in the car after we finished Sunny's rooftop bar.
Yes. Now, I need to ask you some questions about what happened at the end of the night. Miss Levin, you left the bar at around 11:45.
Yeah, I closed out my tab at 11:41. I think that's what I remember. It said on the receipt. And then I got in my Uber at around 11:50.
Right. You decided to call yourself an Uber that night.
Yeah, I called myself an Uber.
You offered that Uber to Miss Marks.
Yes, I did.
In fact, you offered that Uber to Miss Marks multiple times.
Maybe I did tell her, I did offer her the Uber and say, hey, do you want to get in?
You asked her that at least twice.
It might have been, yes.
And so she refused to take that Uber.
She said that she would rather drive.
She chose to get into her car and drive home that night instead.
Yeah, she got in her car.
Thank you. No further questions. Thank you, Miss Levin, for being here today.
Any retract?
Yes, Your Honor. Miss Levin, when Jessica Marks decided to get in her car, was she sober? Going home from Sunny's?
She had, like I said, she had drinks at the bar, and no, she wasn't.
Thank you. No further questions, Your Honor.
Any recross?
No, Your Honor, no recross.
Ms. Levin, you are excused. And let us proceed with plaintiff. Any further witnesses?
No, Your Honor. At this time, plaintiff rests.
Defense. Please call the first witness.
Yes, Your Honor, we call Sunny Mehta to the stand.
Please proceed.
Good morning, Mr. Mehta.
Good morning.
Could you please introduce yourself to the court?
Sure. My name is Sunny Mehta.
And Mr. Mehta, what do you do for a living?
I'm an entrepreneur. Right now, I'm trying to figure out what to do post-pandemic, but for the last few years, I was the owner of Sunny's Rooftop Bar.
And were you working at Sunny's Rooftop Bar the night of March 24th, 2019?
I was.
Do you remember your customers from that night?
I do. I remember that Jessica Marks was there that night.
Are you aware of what happened to Miss Marks that night after she left your bar?
I am. I know that she died.
Now, before I ask you what you observed of Miss Marks that night, I want to address what has happened during trial. Mr. Mehta, you saw a video play on the screen, correct? Exhibit 10?
I did.
Mr. Mehta, did Miss Marks ever act that way when you were taking her orders or serving her drinks?
No, she didn't.
Mr. Mehta, now, did you have any reason to believe her friend was not sober that night?
Morgan Levin?
Yes.
Yes, I did.
Why would you say that?
Towards the end of the night, Morgan Levin actually seemed a little bit drunk.
And why would you say that she seemed a little bit drunk?
She was stumbling around. She's kind of slurring her words, I remember.
And what did you do when you thought Miss Levin could have been a little bit drunk?
I wanted to make sure that Miss Levin wasn't going to be driving home, so I asked her.
And what did you say?
Actually, Jessica Marks said that she would be the one driving them home.
Mr. Mehta, have you ever had to cut someone off in your bar?
I have. I mean, it's part of the job.
Around how many times that does happen?
Gosh, I don't know, more than I can count, honestly.
Now, let's move on to your account of March 24th, 2019. When was the first time you saw Miss Marks that night?
I first saw her around 9 when she came into the bar.
Let the record reflect that we are screen sharing a timeline of the symptoms Miss Marks displayed to Mr. Mehta. Mr. Mehta, did Miss Marks seem intoxicated to you then?
No, I mean, if she had looked intoxicated when she came into the bar, I wouldn't even have given her a table.
Co-counsel, could you please add that onto the timeline? Mr. Mehta, when was the next time you saw Miss Marks that night?
A little bit later in the night when they served drinks, ordered drinks, excuse me.
And were you taking her orders the whole night?
I was.
Were you serving her drinks the whole night?
I was.
And at any of the points where you were serving her orders or taking her drinks, did she seem intoxicated to you then?
No, she seemed fine.
Let the record reflect that at no point when Mr. Mehta was taking her orders or serving her drinks, and Miss Mehta seemed intoxicated. Now, Mr. Mehta, when was the last time you saw Miss Marks that night?
I last saw her close to midnight. That's when she left the bar.
Co-counsel, could you please add that onto the timeline? And Mr. Mehta, didn't Miss Marks seem intoxicated to you then?
No, she didn't. I mean, she looked fine.
Co-counsel, could you please add that she looked fine to the timeline? Now, Mr. Mehta, at all these points, how did you know Miss Marks wasn't intoxicated?
Well, to be a bar owner in California, you have to be trained in how to recognize signs of intoxication in your customers.
And how are you trained to recognize that?
I took a state mandated course here in California.
And what specifically do they teach you in that state mandated course?
The signs that I need to look for in my customers, signs of intoxication.
Can you give me some examples of those signs?
Sure. I mean, there are the more noticeable ones like bloodshot eyes, slurred words, trouble walking, spilling drinks. Those are mainly what we look for.
And you, co-counsel, could you please share a demonstrative of some examples of those signs? I want to be very clear about this. Mr. Mehta, at any point throughout the night, did Miss Marks exhibit red or watery eyes?
No.
Could you add that to the timeline? Thank you, co-counsel. At any point, did Miss Marks exhibit a flushed face?
Objection, Your Honor. Speculation.
Ms. Lopez?
Your Honor, we're asking Mr. Mehta what signs Miss Marks showed him. He was there that night. We believe he'd be able to testify to what signs he saw present in Miss Marks. It's his job to know this.
Mr. O'Hara? Okay, go ahead.
Yes, thank you. The question as asked was, at any point throughout the night, did Miss Marks exhibit those signs? It wasn't asked, did you see those signs? Those are two very different questions. We heard testimony already that there were maximum 30-second-ish interactions between this witness and Miss Marks, and that there were only around 8 to 10 of those interactions. So those roughly 6 minutes worth of interaction aren't necessarily representative of a whole 3 hours worth of Miss Marks exhibiting potential symptoms. So this witness can't say for sure that Miss Marks never exhibited those symptoms.
The objection is overruled. Please proceed.
Yes, Your Honor. Mr. Mehta, at any point did Miss Marks exhibit a flushed face?
No, she looked fine.
At any point did you see her stumble or lose her balance?
No.
And at any point when you were taking her orders and serving her drinks, Did she have incoherent or slurred speech?
No, she was fine when I took her order.
Did she show any of the symptoms of intoxication you've been trained to look for?
No, ma'am.
Mr. Mehta, is there any other way to know if someone is intoxicated if they don't exhibit those signs?
No, I mean, if a customer isn't showing me signs of intoxication, then there's really no way for me to know if they're intoxicated.
Do you have any control over what someone does when they leave your bar if they didn't show you those signs?
No, I mean, I can't control what someone does once they leave.
Mr. Mehta, I want to keep talking about what's in your control. Do you have any control over what someone's plans are coming into your bar?
No, I don't.
Co-counsel, could you please screen share previously entered Exhibit 6? Could you please play that video once again?
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
Mr. Mehta, did Miss Marks ever tell you that she was planning on going hard or going home?
No, she didn't.
Did you have any way of knowing that those were her plans?
No, I hadn't even met Miss Marks until she came into the bar that night.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. Good morning, Mr. Mehta.
Good morning.
You've owned and operated Sunny's Rooftop Bar since February of 2017. Is that right?
That's right.
And on March 24th of 2019, you remember Miss Marks coming in.
I do.
You don't remember looking at her ID, though.
I'm sure I checked it, but I've checked a lot of IDs, so I don't remember specifically what it looked like.
But if you were to look at that ID, pre-marked as Exhibit 3, wouldn't you recognize it immediately as fake?
I'm not sure. You'd have to show me.
No, I apologize. I apologize. It seems my screen share is a little bit off right now. But moving on to the next part. Somehow you ended up serving her and Morgan alcohol multiple times over the course of several hours.
I did.
Let's talk more about Morgan Levin. You just testified to her being buzzed while at your bar.
That's correct.
You claim that she was stumbling.
Yes, sir.
You claim even that she had trouble holding the pen to sign her name.
Yes, sir.
A lack of muscular coordination, that's a sign of intoxication.
It is.
So did you ever stop serving Miss Morgan Levin drinks?
No, she started showing those signs toward the end of the night, and that's why I asked her if she was going to be driving home.
Is that a yes to my question? You never stopped pouring her drinks?
Yes, sir.
Okay. And to be clear, you saw the table that Jessica and Miss Levin had that night, right?
I did.
You assumed that Miss Levin and Jessica were finishing all the drinks that they ordered?
I think so. I wasn't up there when they were drinking for the most part, but I think so.
And you still thought that they were sober enough to drive themselves?
Jessica, yes, but not Miss Levin.
Right. So after serving all that alcohol to her table, you thought she was sober enough to drive herself and a friend?
I did. She looked fine.
Okay, well, let's look at the drinks that you actually served to her that night.
Okay.
So you served to her a bottle of decoy wine. Is that correct?
That's right.
That wine, I'm going to write down what you answered, Mr. Mehta. That wine was 14% alcohol?
That's right.
You also served to her 3 White Claw hard seltzers.
That's
Those
what I
are,
served their table. Yes.
that's right. And those are 8% alcohol.
That sounds right.
You also served to her a Ceramis or a IPA can of beer, right?
That's what they ordered. Yes.
That's 6.5% alcohol.
Yes, sir.
You also served to them an IPA draft beer that you served in a pint.
I did.
That's 7% alcohol.
That's right.
You also saw that they had a drink that you didn't serve to them.
I'm not sure what you mean.
Well, in your deposition, weren't you shown that a drink was served to them that you didn't serve to them? It looked like it could have been a Captain and Coke.
Oh, yes, that's right.
Explanation, Your Honor.
Ms. Lopez?
Yes, Your Honor. This question calls for speculation. They're asking Mr. Mehta what that drink that he didn't serve to them was. They laid foundation that Mr. Mehta did not serve this drink to Miss Marks. Therefore, Mr. Mehta would have no way of knowing what that drink is.
Mr. O'Hara?
Yes, Your Honor. We didn't ask this witness what was in that drink. We agree he wouldn't know that. We simply pointed out the fact that there was a drink that he didn't bring to the table, and he doesn't know what it was.
Ms. Lopez?
If Your Honor, opposing counsel just admitted that Mr. Mehta doesn't know what that drink was, we believe this line of questioning on that drink is unnecessary then if Mr. Mehta doesn't know what that drink was.
I think the testimony made clear that he didn't know what it was and just said what it looked like. So the objection is overruled.
Yes, Your
Please proceed.
In the last round of alcohol that you served them that day, Mr. Mehta, were 2 green tea shots, each with 2 ounces of alcohol content. Is that right?
That's right.
Okay, thank you. We'll keep that in mind for later. Now, you also claimed that you saw Exhibit 10 played earlier today. Is that right?
I did.
And if you were, and then you claim that that's not what Miss Marks was acting like in front of you. That's your claim.
Not when I served her. No.
But if you were to see what Miss Marks acted like, if she was acting like she was in Exhibit 10, you might have still served her, wouldn't you?
I'm not sure I understand your question.
It's a hypothetical. If you saw someone acting the way Miss Marks was in Exhibit 10, you might still serve them.
I might. I'd have to gauge how they were acting the rest of the night.
So what you saw in Exhibit 10, the slurred speech, that wasn't enough to make you cut someone off.
I don't know that she was slurring her speech.
You don't think she was slurring her speech in Exhibit 10?
I think it's hard to tell. I don't actually know how she's acting in the video.
All right, we'll write that down. You claim that she's not slurring her speech in Exhibit 10. Do you think she's having coordinated movements in Exhibit 10?
From what I remember, yes.
You think her movements are coordinated in Exhibit 10?
From what I remember, yes.
All right. And how about her eyes? Are those clear eyes?
I remember it looks like she had red eyes. I'm not sure if that was because of the camera. I don't know.
All right. So in your mind, though that person in Exhibit 10 isn't exhibiting those symptoms of intoxication.
I think the person in that video might look intoxicated. I think they might not, but I don't know what to tell you. I just didn't see that.
And you think that Miss Marks wasn't intoxicated that night?
Not when I saw her, no.
Okay. Thank you, Mr. Mueller. No further questions.
Any redirect?
Yes, Your Honor. Mr. Mehta, when you were interacting with Miss Marks, what signs of intoxication did she show?
She wasn't showing me any signs of intoxication.
And do you have any control over what they do if they don't show any signs of intoxication?
No, I mean, if she was showing those signs of intoxication, I would have cut her off, but she wasn't, so I didn't.
Thank you, Mr. Mehta. No further questions.
No recross, Your Honor.
Very well. The witness is excused. Ms. Lopez, any further witnesses?
No, Your Honor. The defense rests its case in chief.
Well, we will now hear closing arguments from each party. Everyone should please switch back to speaker view. As both witnesses have completed testimony, you can complete the witness portion of the ballot. Well, I'm going to do this like Anta, so defense, closing argument, please.
Your Honor, I'm sorry, did you say defense or plaintiff just now?
Yeah, plaintiff has put a, were you told something different about the order of closings?
I thought plaintiff went first,
All right, we'll do plaintiff first.
but I'd be fine going first if not.
Oh, it seems
Yes.
like you want to do plaintiff first. So, Mr. O'Hara, closing argument, please.
Yes, Your Honor. One moment so that I can get my setup.
Counsel, we don't have audio.
I apologize, Your Honor. That's why we check.
You may
Um,
proceed.
Thank you. The difference was who was serving her. Members of the jury, I hope there's something that you remember to do throughout today's trial, and that's to use your common sense. Because that night, the 24th, the defendants weren't using their common sense. And because they didn't use their common sense, they kept on pouring alcohol onto the table that Mrs. Marks and Miss Slevin shared. And as a result, Miss Marks couldn't use her common sense. She died because they deprived her of that. Now, there's nothing that can be done to make that any better. Miss Marks is never going to come back. But what we can do is to invoke the California Dram Shop Act. Now, the Dram Shop Act makes it that if bars, like Sonny's Rooftop Bar, overserves a minor, an obviously intoxicated minor, and the minor gets hurt as a result, then that bar is held liable. And we're going to show you that we meet that burden to hold this bar liable under that law. So if we could get my co-counsel, Ms. Hill, to screen share a basic outline of what we're suing Sonny's Rooftop Bar under. You can go ahead and look at the bolded portion. Don't worry about reading the rest for now. That part of our burden is undoubtedly met because those facts are uncontested. It's uncontested that Miss Marks died, that she drank alcohol at Sonny's Rooftop Bar, and that she was a minor. That much was proven before we stepped into the courtroom today. And the next part of our burden is just as easy to prove. You see, prior to today's trial, we pre-admitted a police report from Officer Sammy Gaskins. Officer Gaskins interviewed every witness that we've heard at trial today. Officer Gaskins collected almost every piece of evidence that we have in our disposal today. He's highly qualified in his field and specifically in this case. He concluded his report by saying that he found it to a reasonable degree of professional certainty that Miss Marks died as a result of intoxication, that's what caused the crash. That's the second part of our burden, and it's undoubtedly met. And the third part of our burden is showing that Miss Marks was obviously intoxicated. Now that's the trickiest part of our burden to prove, not because it's not true, but simply because it's the hardest, it's the place where we have the least objective evidence, but we have more than enough. And if you just look at the evidence and use your common sense, you'll see that we've proven that part just as well as the others. So first, the volume. The volume that she drank is massive. To start, almost an entire bottle of 14% alcohol decoy wine. 3 8% alcohol hard seltzers. A 2-ounce alcohol green tea shot. A 6 to 7% alcohol draft beer. That is the conservative estimate. Sunny knew exactly how much alcohol was in these drinks, and she served them anyway, over and over again. She never stopped. Next, we have the testimony. You heard from Miss Mehta today that, or Mr. Mehta, I apologize, that he never stopped serving, and that Mr. Johnson, as far as he knew, never stopped serving, and that he wouldn't have stopped serving even if he did observe those symptoms in Exhibit 10. Members of the jury, think about that. Slurred speech. You saw Exhibit 10 with your own eyes. They can't tell you otherwise. He would have kept on serving them. In fact, you might want to consider what Mr. Mehta considers to be obviously intoxicated, because he claimed the person in Exhibit 10 who saw all those symptoms, those objective symptoms, never knew that she was intoxicated, claimed that she wasn't intoxicated in that video. Now, that's where we beat the crux of this case, because ultimately, it's common sense. There's 3 things we asked you to remember today. First, a question. What was different about that day? Why that day out of any other? Second, a reminder to use your common sense. And third, the answer. An answer we reminded you of multiple times throughout this trial, an answer to the question asked. The question is what was different. The answer is who was serving her. Find the defendant liable for the wrongful death of Jessica Marks. Thank you.
Defense, closing argument, please.
Yes, Your Honor. Your Honor, members of the jury, may it please the court. Go hard or go home. That is what Miss Marks said the night of her death. That is what she planned to do before she had even left her home for the first time that night, before she'd gotten into her car for the first time that night, long before she had even arrived at Sunny's rooftop bar. She planned to go hard or go home, but she did not plan to do so responsibly. The plaintiff has brought a claim for wrongful death under the California Dram Shop Act against Sunny's rooftop bar. And in order to prove the bar liable, they needed to prove to you 2 things. They needed to prove to you that Miss Marks was served when obviously intoxicated, that any reasonable person in the position of Sunny's rooftop bar would have known Miss Marks was too drunk to drink. And they needed to prove to you that as a result, Miss Marks died. Now, Sunny Mehta came up here and testified today, and that is why the plaintiff did not meet their burden. Sunny Mehta told you that he is trained to identify the symptoms of intoxication, and that because he did not see any of those signs, he did not serve someone who seemed obviously intoxicated. He told you the unfortunate truth, that if someone does not seem obviously intoxicated, that if someone does not show those signs, they can't do anything. Their hands are tied. And we know Mr. Mehta would have done something if necessary, because we know that Miss Marks' friend, Miss Levin, did seem a little drunk at the end of the night. And so Mr. Mehta made sure that she was not driving home. He made sure Morgan Levin was not driving home that night, because he knows that it is part of his job to make sure obviously intoxicated people are not driving home. I just told you that if plaintiff needed to prove that a reasonable person would have known Miss Marks was too drunk to drink, let's briefly talk about what being a reasonable person is. A reasonable person cannot know what they do not see. A reasonable person cannot say someone is obviously intoxicated without seeing those signs. And that is why you cannot hold Sunny's rooftop bar liable today. But even if you think the plaintiff has met their burden, you have to consider the defense's affirmative defense, the fact that the defense had a burden as well. Today, the defense needed to prove to you that it was Miss Marks's own negligence that caused her death that night, that Miss Marks failed to use reasonable care that night in order to prevent her death. Now, let's talk about how she did that. But first, let me be the first to talk about the tragedy of that night. March 24th was a tragic event. It was unfortunate that Miss Marks should not have died. We all wish she would not have died. But the truth is, Sunny's rooftop bar could do nothing about preventing Miss Marks's death. And I understand that it's hard to ask you to look at her decisions and place the blame on her shoulders. Not only because she's a young girl, but because we as humans, we want to be able to pinpoint what went wrong somewhere so we can fix it. And that's so much easier to do if you find Sunny's rooftop bar liable. But in this case, what went wrong was not the decision Sunny's rooftop bar took. It could have done no more. Part of what went wrong is just that the signs were not visible. And the other part that went wrong is Miss Marks's own negligence. Negligence is the failure to use reasonable care to prevent harm to oneself. Driving after drinking is not taking reasonable care. Planning to drive home after a night where you plan to go hard is not taking reasonable care. Refusing an Uber multiple times is not taking reasonable care. Let's examine Miss Marks's plan of going hard or going home, and we can see the instances where Miss Marks failed to take reasonable care. First, at her Airbnb, she had glasses of wine, and that's where she shared her plan of going hard or going home with us that night. Then she chose to drive herself to Sunny's rooftop bar. She arrived at Sunny's rooftop bar, and that's when she ordered multiple drinks multiple times. And here I just want to say, Mr. Mehta just served those drinks to her table. He did not know which drinks Miss Marks was finishing, for sure. And finally, Miss Marks was offered an Uber, but she refused it multiple times. And she decided to drive herself home that night. If we were to take Sunny's rooftop bar outside of this sequence of events, everything would still stay the same. With the snap of my fingers, we can change this to any other bar, any other person serving Miss Marks, and Miss Marks's plans, Miss Marks's choices, and the night's outcome would all stay the same. So there is nothing else Sunny's rooftop bar could have done, but there is a lot more of what Miss Marks could have done. That night, there was someone else at that bar who had also drunk, Miss Marks's best friend, Miss Levin. And she decided to call herself a Uber. That is what a reasonable person would have done. That is taking reasonable care, and Miss Marks could have done the same. Miss Marks planned to go hard or go home, but she did not plan to do so responsibly. And because of that, I ask you to hold Sunny's rooftop bar not liable. Thank you.
Judges should thank you very much and congratulations on finishing the first trial.
Your Honor, the plaintiff does get a rebuttal.
All right. Let's do that. Plaintiff, rebuttal, please.
Thank you, Your Honor. she did want to go home, but she couldn't. Members of the jury, think of the irony of what you're hearing today. You can see in your jury instructions that a symptom of obvious intoxication is poor judgment. You heard that Miss Marks had consistently good judgment when it came to driving herself home, taking an Uber or walking, enough that she never got a scratch on her before the 24th. The 24th is the day things were different. Miss Marks wasn't different. The alcohol wasn't that different. The vehicle wasn't that different. The difference was who was serving her, because the person who was serving her on that day didn't stop serving her. Now, as Officer Gaskins mentioned in his report, this wouldn't be the first time that Mr. Mehta and Mr. Johnson, those two exact bar workers at Sunny's, failed to realize that a minor was intoxicated enough to be a danger to themselves. Back in 2018, only a year before, less than a year before, in fact, Miss Marks had her tragic accident. There was someone named Joe Quang who tripped and fell as a result of how much they gave him to drink. And that time they pled guilty and they were given punishment. And after they were found guilty of serving a minor again in Miss Marks's criminal trial, they had their license revoked. So think of who you're listening to here. Yes, it's someone who is trained to recognize when someone is obviously intoxicated, but it's someone who had that license revoked. And the other one, Mr. Johnson, he ended up leaving to sell taffy.
Mr. O'Hare, I believe the time has elapsed. So I think we're really done with,
Your Honor, may I object to something that just happened during the rebuttal?
please go ahead.
Your Honor, we're objecting to character evidence that wasn't brought up during the plaintiff's case in chief, specifically about bringing up knowing other people have been minors and still serving them before. That wasn't mentioned during the plaintiff's case in chief, and therefore we believe it shouldn't be taken into the jury's accounts just as because it was only mentioned during the rebuttal.
Your Honor, may I be heard?
You may.
This recounting of serving a minor was from Exhibit 23, which was pre-admitted, which means it's in evidence, even though it didn't come out during trial. So it's admissible for me to use during my closing statement or closing arguments.
Your Honor, if I may.
You may.
We're not objecting to Exhibit 23. That's the police's report. We're objecting to the recounting of Mr. Mehta previously serving someone who was a minor. We believe that's being used as character evidence, and we couldn't object to it during the case in chief because it wasn't used, so we would like to object to it now.
Do you want to respond to the character evidence point, Mr. O'Hara?
Yes, Your Honor. May I show you the report that we're referencing?
You may.
This report was moved into evidence before today's trial, which means it doesn't matter that it came out, whether or not it came out during today's trial. What's important is that it's here. You can see that Sunny's has a reputation for serving underage high school students, and specifically the minor that we mentioned, serving another minor, Joe Quinn, who fell outside after being overserved and was badly hurt. That's what we're referencing. It was already in evidence. It's admissible for us to use during closing arguments.
Your Honor, if I may just briefly one more time.
Be free.
Your Honor, I realized I had the wrong exhibit in mind. We're not objecting to the exhibit as hearsay per stipulation. We understand that that exhibit is entered, but we still believe that there can be character evidence within that exhibit. And in that exhibit, character evidence by reputation is still character evidence and is still not admissible. Therefore, we believe that referencing that part of Exhibit 23 is character evidence and should therefore not be allowed.
I'm going to take the objections under advisement. And if there's nothing further, that concludes the closing arguments.
Yes, Your Honor.
And finally with that, the judges should now complete their ballots, and when they're done, click submit. I ask everyone to stay on until everyone submits the ballots, and then we can proceed with comments.
Yes, Your Honor. Thank you.